Yes, Mr. Yes, please.
If I may be permitted to move in a unlisted motion.
What is the urgency?
Urgency because I am going to be dispossessed and evicted from my property tomorrow.
Okay, okay, okay.
It is very much.
Okay.
Much better. No, please, my lord.
Yes, what is that causeless? What is all this? Yes.
Lordship, I beg to mention hearing item number 15.
15.
Yes, my lord.
Yes.
If this matter can be listed up to 3 weeks, I have taken that position from the other side.
Okay, ma'am. On the prayer of Mr. N. Angami, learned senior government advocate, listed after 3 weeks.
Lordship is in interim.
Okay, stop. The interim order passed earlier shall continue till the next returnable date.
I'm deeply obliged.
My pleasure, sir.
Yes.
My lord, I think commission item number 12 and 13 on behalf of Mr. Yanawati. Let this matter be passed out for today.
Mr. Zetan Muli, learned counsel makes a mention on behalf of Mr. Yanawati, learned CGC, and seeks adjournment of the case for the day. Listed after a week.
May I please, my lord?
Yes, please.
Lordship, I beg to mention hearing item number 14. Lordship, can this matter come up after 2 weeks?
Why?
My seniors are stationed.
Yes, Mr. Ejimomi.
I taken the consent of senior contact. Informed this morning, otherwise I come up on this case.
The issue is very limited. The issue is very limited. Anyhow, we Listed after 2 weeks.
Yeah.
It's Imchan, correct?
Lordship Ali Bosman.
Are
Yes, for respond number two.
on the prayer of Mr. Aliba Uzgam,
Yes.
the learned counsel for the private respondents, listed after 2 weeks.
Much obliged.
For motion, item number 1. Yes,
Maybe it's working.
yes, what is this IA, ma'am?
But you need to submit. It's safe for the work.
Okay. What is the issue in the IA?
Where occurred the always before the 1 the petitioner had like.
24
The text steps from the number 3.
This is a text steps, but we have the okay, so what is wrong with this order? Okay,
Also, the petitioner, however, the private respondent refused to accept the notice. Hence, this petitioner.
okay, it's all right, then, we deem the notice, who is respondent number 2? Who is respondent number 2? Respondent number 3, respondent number 3,
Three is the private respondent.
private respondent. Okay. Ready? This is not. But madam, I think there is something small but horribly wrong with your application. You are saying instead of dusty, you are saying dusty, that dust particle, DUSTY. Dusty service, not DASTY, but dusty, DUSTY. See your paragraph 4. Hand over the dusty, yes. And that is repeatedly mentioned again, dusty, DUSTY. Dusty service. Litra service. Kindly make correction. I have just marked it. Correct that dusty, DUSTY. Instead of that, you write DASTI. And give your signature. So the respondent number 3 has refused to accept. Correct. Okay. It's all right. Okay. Had MS Winslow, learned counsel for the petitioner, and MSS Mary, learned senior government advocate for the state respondents. On 28/3/2025. The learned counsel for the petitioner had submitted before the court that service of notice upon the respondent number 3 by dusty process had been served. However, the respondent number 3 had refused to accept the notice. Stop. In view of the submissions made by the learned counsel for the petitioner, this court had accordingly directed the petitioner to file affidavit stating that service of notice by dusty process was effected on the respondent number 3, but the said respondent had refused to accept the notice. Stop. In terms of the order dated 28/3/2025 passed by this court, the petitioner has filed the application / affidavit dated 11/4/2025. Stop. The notice upon the respondent number 3 is therefore deemed served. Is therefore deemed served. And the case shall proceed ex parte against the respondent number 3. Stop. MSS Mary, the learned senior government advocate is allowed 3 weeks time to file the affidavit. Oh, okay. Rejoinder, MS so and so, the learned counsel for the petitioner is allowed 2 weeks time. Okay, 2 weeks. Is allowed 3 weeks time to file reply affidavit to the affidavit in opposition filed by the state respondents. Listed accordingly. Okay. Yes. For admission, item number 2.
My lord, in this matter, my lord, I am appearing for respondent number 5, 6, and 7.
36.
My lord, we have 5, 6, and 7. My lord, I have already filed the affidavit. And so far as my lord, respondent number 9 is concerned, who is a newly imputed respondent, my lord, I have taken instructions from the department. My lord, we will not file a separate affidavit. My lord, respondent number 9 will endorse the affidavit already filed by respondent number 5, 6, and 7. So, my lord, that may be recorded, my lord, and matter may be fixed for admission hearing, my lord.
Mr. Chiba, you have filed your.
Yes, my lord.
You will not be filing your rejoinder. No. So we can list it for hearing.
My lord.
Third, MS so and so, learned counsel for the petitioner. Comma, Mr. E. Kibapon, learned government advocate for the state respondents. And Mr. Your name?
H. Gupta, my lord.
And Mr. So and so, H. Gupta. Learned counsel for the respondent number 5 to 9.
5, 6, 7, and 9, my lord.
5, 6, 7, and 9.
Yes.
Okay. 5, 6, 7, and 9. Mr. H. Gupta submits that. Learned counsel submits that. The respondent number 9 endorses to the ground taken by the respondent number 6 and 7 in
5, 6, and 7.
5, 6, and 7 in the affidavit in opposition.
My lord.
Stop. Pleadings are completed. List the keys for hearing in the usual course.
Obliged.
For admission, item number 3. Yes, ma'am.
Your Lordship, the case of the petition is under consideration, Your Lordship.
That was the submission made
Yes,
last
sir.
time also.
Yes, Your Lordship, what happened is that, Your Lordship, the petition was sent, but not only the petition, but 62 was sent,
Okay.
82 was sent. However, the petitioner's case was rejected because of incomplete of documentation.
Okay.
And so it was sent again, so it is lying before the government, so Your Lordship, another 6 weeks may be granted, Your Lordship, so within that time, Your Lordship.
Okay. Well, what is your case?
My case is for regularization.
Okay. So if the government is taking some steps to consider your case, then
Yes, my lord.
okay. MS Livika, learned government advocate submits that. The case of the petitioner for regularization is in service is under active consideration of the government, and therefore she may be allowed 4 weeks time. No. I think that 4 weeks time to place the up-to-date status report on the next date. Listed accordingly. Listed after 4 weeks. For admission, item number 4.
Please, Your Lordship.
Yeah.
Lordship, I have just received the affidavit in reply.
Okay. Okay.
I will give it some time.
We listed for hearing. The pleadings are complete. Is there any private respondents? Respondent number 6, whether respondent number 6 has filed affidavit?
So far, the respondent was this morning.
Okay. So respondent number 6 has also filed. Okay. You have filed a reply. Reply to respondent number 6. So, okay.
Fix for having on.
Yes.
Before this now.
MS so learned counsel for the petitioner submits that the affidavit in reply filed to the affidavit in opposition of the respondent number 6. The affidavit in reply has been filed to the affidavit in opposition filed by the respondent number 6. Stop. The affidavit in reply is however not on record. Registry to verify the same in place on record. The stop. Learned counsel for the party submits that the pleadings are completed and the matters can be listed for hearing. Listed for hearing in the usual course. Okay.
For admission, item number 5.
Your lordship.
Yes,
In
please.
this, I've sent the application for the.
Okay, okay.
Pending given the last.
Mr. M. Lunkumar, the learned government advocate submits that the affidavit on behalf of the state respondents has been sent for waiting. He may therefore be allowed 2 weeks' time to file the same. Prayer is allowed, listed accordingly.
For admission, item number 6.
Yes,
Questions, Your Lordship?
yes.
Any documents that will probably be in plan.
Okay, okay. MS so learned counsel for the petitioner is allowed 2 weeks' time. 3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents, listed accordingly. Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Right.
For admission, item numbers 7 to 10.
Please, my lord.
Yes.
The respondents are identified there. Counter.
My lord, I want to go to Yangalwati. Instruction not yet to go.
CGC.
Yes.
CGC.
Yes. That is not maybe come up after 2 weeks.
Okay, yes, yes. No state respondents.
No.
No. Okay. Mr. Zaitan Guli, learned counsel, makes a mention on behalf of Mr. Yamrawati, the learned CGC, and seeks adjournment of the case for 3 weeks to file affidavit in opposition. Prayer is allowed, listed accordingly.
Right.
For orders, item number 11.
Yes.
May I please, my lord. Lordship, here, we are unable to take the steps as well as to file the appeal against the same order, since we are unable to conduct the business.
Oh. So, but this is, I think this is for the state to file affidavit.
Yes, my lord. Yes.
And your, that appeal is, that is totally a different issue. Correct?
For the indictment, lordship.
You were actually supposed to file appeal no, against that, that order.
Yes.
So that is a different issue.
No, it connects to this petition because it was in this case, your lordship has passed an order to impede the 6 tribes, whereas.
Yes.
We have filed for review.
And yes, correct.
Kindly allows 3 weeks time, so that.
In the meantime, you file your affidavit also. Let us see.
The state has to file a comprehensive.
Correct, correct. Okay. You are on behalf of Mr. MT?
Lordship.
Yes. Mr. Kiangami. The learned counsel appears on behalf of Mr. M. Timson, learned additional AG, and seeks adjournment of the case for 3 weeks to file affidavit in opposition. Prayer is allowed, listed accordingly. We are not making any observation on that issue.
Lordship.
Okay, we are giving 3 weeks time. In the meantime, you can take steps. Okay,
Much obliged.
Yes. yes.
For unlisted motion, WPC 63 of 25.
Yes, Mr. What is this?
This responded with the kind of order. So the petitioner made some notes from the bank board. Alleging that the loan remained unpaid. OA number 235 of 2018 was filed with the DRT in Gauhati for claiming the sum of rupees 56 lakhs 8,479. During the pendency of the case, the matter was referred to Lok Adalat.
Okay.
Lok Adalat passed an order on the basis of a compromise deal between the petitioner and the Bank of Baroda. And the Bank of Baroda agreed to accept the sum of rupees 26 lakhs as full and final settlement against the entire dues of the petition. That was the order passed by the Bank. Now, I could not, because of my ill health, I could not meet the time frame fixed for the payment of that 36 lakhs. So, in the month of August 2024, a notice was issued against me, an order was passed against me, saying that.
By? Order was passed by?
At the instance of the Bank of Baroda, to the additional district magistrate Dimapur for taking possession of my land. In terms of orders passed by the I submitted a representation. The chief manager and the district administrative officers, the EAC revenue, they came to my house and they suggested that I open a savings bank account in the name of my wife and deposit the entire amount of 36 lakhs during a period of 3 months. Now, again, because of my ill health, I cannot do so, but by November of last year, I deposited the entire amount of 36 lakhs in my account. And I wrote letters to the Bank of Baroda saying that the amount should be deducted and my account should be closed. Now, after that, in the month of December, again, I received another notice saying that my matter has been placed before the law. Again. I went down to Gauhati, I met a representative of the bank. In that meeting, I was instructed to pay a sum of these 5 lakhs so that the negotiations could proceed further. I agreed. I waited for this person to return, he never returned. The Bank of Baroda. Subsequently, I received the order which I am now including in this petition. You should find that in annexure 12, page 43. Page 43. Last meeting. Page 43. Dated 28 March 2025. May I read now? In succession to this office order of even number dated 5th August 2024. So this is the previous order which I was referring to earlier. And as per the request of the authorized officer, Bank of Baroda is nothing but taking possession of the secured assets as noted below under section 14 of the Surfacing Act of 2002. The secured asset which is mortgaged by the borrower, Shibuto Aoni, is within the jurisdiction of the district magistrate London. And whereas the perusal of the application and its annexures, it inspires that the secured creditor has granted a loan of rupees 6 lakhs 50,000 to the borrower on 27/6/2006 and is defaulted in payment of the outstanding loan amount and accrued interest aggregating to rupees 3 crores, etc. Now, Your Lordship, the 36 lakhs, which is not recorded as a settlement between the petitioner and the Bank of Baroda, has not been ignored. Consequent to such default, the account of the borrower has been classified as non-performing asset. The authorized officer has submitted that under section 13(2) of the Surfacing Act of 2022 has been duly issued, which has been received by the borrower and never received such a notice in action. And in section 14, notice is required to be issued. That also I have not received any notice. I just received this document alone. Now, therefore, as recorded in section 14 of the Surfacing Act of 2022, and in view of the above, I am inclined to allow the incident application. Accordingly, the extra assets commissioner, the revenue department, is hereby given to take possession of the secured assets and after completing all formalities on 16/4/2015, that is tomorrow, and shall hand over the same to the secured creditor Bank of Baroda. The deputy commissioner of the department will take necessary action providing police force to control law and order. The secured creditor shall contact the said concerned police authority.
Mr. H. Momi, I think there is an order passed by the Supreme Court that giving a direction to the high courts that the Andhra Surface Act, the Article 226
This one.
should not be
Yes.
resorted to.
No, but I am not a surface member. I'm not a surface, I'm coming to that. This is a very interesting case, Lordship. And I am filing this case on the basis of simple principle, which I have placed before your Lordship. This is not under surface per se. This is about an order passed by a local law.
Where's that? Look, let's see.
Now. Your you can see that in. Page 17. Page 17. Condition 1. Page 17, condition 1. That copy is in the next page, at page 18. Page 18. Is it about to come? Page
Just
18?
wait.
That copy. It's dated 35/23. Yeah, read my one.
Mm-hmm.
The case is called off in the reconciliation camp under the age of the local government. My lord, we can do that. This is why the deciding of the officer of the DRT, but it is a proceeding of the local government. Chairman Kumar manager is present in person for his application for the bank. Chief Yuta Aomi is present in person. The compromise deed is filed, it is signed by the parties, the contents are verified, and it is accordingly recorded. As per the terms of the compromise, the entire satisfaction of the claim amount to recorded at rupees 36 lakhs. Only the compromise deed shall form part of this order. In the event of default of payment of any part of the settled amount and a part of any sums as stipulated here above, and or if there is any prejudice to the security of the recording bank and or breach of any term of settlement, the reliefs and concessions granted to the defendants shall stand withdrawn without any further reference to the defendants, and recovery certificate will be executed. Recovery proceeding will be restarted, resumed in terms of the recovery certificate issue. Copy of this order will be uploaded in the tribunal's website. Now, if I may pause here for a moment, Your Worship.
This is the order passed by the DRT.
Yes,
Where is the order passed by the local adalat?
this is the local Adal order, Your Worship. So the DRT officer is sitting in the local Adal. And he passes, he records the award to local Adal in the formal order, Your Worship. And the compromise is at page 19.
So you mean to say that this page 17 is the order passed by the local
Yes, sir.
adalat?
It is passed by the presiding officer of the DRT in the local Adal. Sitting in the local Adal. This is how it is done, madam. This is how it is done. Okay, my point, we stop here for a moment and reflect on the order dated 35/23. Your Worship, as far as the legal services authority is concerned, the first part of the order, which stops at, which records the compromise of rupees 36 lakhs as the full and final settlement of the debt owed by the petitioner. That is the jurisdiction of the local adalat. And the local adalat of the jurisdiction stops there. The second portion, Your Worship, in the event of failure, the case reverts back to the reference code, which is the DRT. This is void, Your Worship. This is without jurisdiction. This is against the decision of the Supreme Court, at least that much. And this part is very interior in terms of the decision rendered by the Supreme Court. The only part which is good insofar as the order dated 35/23 is concerned is the record of the rupees 36 lakhs as the full and final settlement of the deed. And this order is based on the compromise deed, which is in section 2 at page 19. Section 2 at page 19. Your Worship, got it?
Just wait, let me have a look at this 13. Why do you say that this the second part of the order is pretty clear?
Clearly records the compromise. It has got no authority, no jurisdiction or judicial orders. And I will satisfy your Worship on that point on the proceedings of the Honorable Supreme Court. The Supreme Court is very clear on this. It has got no business incorporating penal clauses in the order of the law. The law does not have any authority to incorporate penal clauses where it's not. Because, Your Worship, the point is this, in terms of the Legal Services Authorities Act 1987. Once an award is passed by the Lok Adalat, once an award is passed, the office in question becomes factus officio. So the DRT, acting in terms of the National Legal Services Authority Act, when it passes the Lok Adalat Act, its jurisdiction in the matter ends
Kindly read that second portion again. In the event.
in the event of default of payment and any part of a certain amount and or any installments as stipulated here and above, and or if there is any prejudice to the securities of the applicant bank and or breach of any terms of settlement, the reliefs and concessions granted to the defendants shall stand withdrawn without any further reference to the defendants, and recovery certificate will be executed. Recovery proceedings will be.
That is, it means that actually if there is a default in payment of 36,000,
Yes.
36 lakhs.
Yes. If there is default in payment, then it will revert back to the DRT.
Ah,
And they go by the.
so why this portion is wrong?
Yes, because in terms of section 21, because in terms of section 21 of the Legal Services Authorities Act, the award of the Lok Adalat is binding.
But suppose if actually there is a failure on the part of.
There is for them to file an execution petition. That is also certain law option, and that's why I'm coming to that. The DRT becomes factus officio as far as this original application is concerned, once an award is passed. You cannot take back the case saying that the award of the Lok Adalat has not been satisfied. That is the law which has been done by the Honorable Supreme Court. I will place you in authority very much. So therefore, Your Lordship, the DRT would not have taken back the case and enhanced the dues to 3 crores or revive the case. It would not have thereafter issued proceedings for the.
Let us see that the agreement.
The agreement is on these lines, Your Lordship, as reflected in the order, at page 19. Annexure 2. Right copy is at page 21. Beginning of the
So
first-
on the basis of this agreement, the order was passed by the local Adalat.
Yes, ma'am. And this agreement has been signed by all the parties. The bank, as well as the petitioner.
Now subsequent to this 13/5/2023, what steps the petitioner have taken? Where? Where is that?
By November 2024.
Where is that deposit?
You want to see initial page 28. Which we did all of the other steps. All the steps, and then the
Page 28.
beginning from page 28. And then the 11th page of the passport, that also I have includes the one. Up to page 34. Up to page 34.
28 to 34.
36, that copy is also there. Page 36.
The deposit slip is annexure 6. Only. Annexure 6.
And it continues.
No, the annexure is only one, annexure 6.
The initial 7 is the 11th page of the passport. I'm sorry, 11th page of the passport, 11 pages of the passport,
Which page?
page 32.
32.
Is the cover. Then page.
This, just wait. This is self-service saving account passbook. The entire amount is deposited in this account. This, what is the account number?
That the account number is
18, is it?
in page 33.
Page
33.
33. Oh. What is that account number? This actually, you have actually stapled all this.
78301
78301.
220 260 That copy is at page 35.
Okay,
Remove it and that copy.
So your case is that despite the deposit being made, the deputy commissioner has issued the impugn order.
At the instance of the bank. At the instance of the bank. But not only that, Your Lordship. The deposit of the entire amount is one aspect of the matter. Proceeding against me. After the award of the Lok Adalat, Your Lordship. Proceeding against me under the surfacing. That is an action without jurisdiction. That is an action without jurisdiction.
Any citation on this?
Yes, my lord.
Yes, let me see.
Yes, my lord. The first one, Your Lordship, this is the leading case, this is the state of Punjab and Nabal versus Devosh Singh. There was 660 paragraphs 9, 10 and 12. The Lok Adalat should guide and persuade the parties with reference to the principles of justice, equity and fair play, to compromise and settle the dispute. It cannot assume a judicial role. That's why I was saying, Your Lordship, the second part is bad. An order of the Lok Adalat, which is contrary to law and beyond the power and jurisdiction of the Lok Adalat, is void in law. The second part is void in law. Your Lordship. an award of Lok Adalat is final and binding on the parties and becomes executable as if it is a decree of a civil court. If any party wants to challenge such an award, it can be done by filing a petition under 226 and up to 27 of the Constitution, that too on very limited grounds. So if the Bank of Baroda is not happy with the award in Lordship, they can come to this order court by filing a petition under 226 and 227. They cannot revert back to the DRT. Then number two,
No, Mr. Jimumi,
yes,
how can we treat the order of the Lok Ayukta in piecemeal?
look
Lok Adolat in piecemeal. One part you said this is perfectly okay.
yes,
The other part is not okay.
because it is.
So the confusion of this court is, okay, should we treat the order of Lok Adalat in piecemeal?
Of course, Your Lordship, it can be done in Lordship. The doctrine of severability, Your Lordship.
Hmm.
As far as the second part is concerned, it is in the teeth of judicial procedure, Your Lordship. It is in the teeth of judicial procedure. It can be ignored, it is per inquirium. It is per inquirium, Your Lordship. Can the DRT override the decision of the Supreme Court, Your Lordship? The Supreme Court very clearly in this case says, Lok Adalat is the effect of compromise between the parties. It cannot take any judicial decision thereafter. It cannot impose any terms.
Let
It
us
cannot
see,
violate compromise.
let us see the books. Let us see.
First, can we go to the second one of the
Huh.
This is 2012, 2SC 51, paragraphs 20 and 26. Once an award is passed, the reference code becomes functus official. So the DRT becomes functus official, Your Lordship. The party cannot revert back to the DRT once an award is passed by Lok Adalat.
Hmm.
The award of the Lok Adalat shall be deemed to be a decree of a civil court and as such executable by that court. So if I did not pay back the rupees 76 lakhs, which was passed by the Lok Award, the award passed by the Lok Adalat, the only course option for the Bank of Baroda was to file an execution petition, not revert back to the DRT emotion. So therefore, the proceedings after the order of the Lok Adalat are absolutely without jurisdiction. And they confer no rights, orders without jurisdiction confer no rights of any party. The third one is watching. This is a case from the Patna High Court, and the Patna High Court case is very similar to our case in watching. And in this case, the Patna High Court deals with the entire aspect of orders passed by the party in the light of the judgments passed by the Honorable Supreme Court. And a case is also a watching for your lordship's consideration.
Okay, let us see. Let us read one by one. Let us see this
First, the first
2008.
2008, 2SC, 660 paragraphs 9, 10, and 12. Paragraph 9, that means 665,
9, 10.
9, 10, and 12. May I read now?
Yes.
What we find sitting on trial judge while participating in Lok Adalats as members tend to conduct the Lok Adalats like courts by hearing parties and imposing their views as to what is just and equitable on the parties. This is precisely the point I'm trying to say about it. Sometimes we get carried away and proceed to pass orders on merits as in this case, even though there is no consensus accepting. Such acts, instead of fostering alternative dispute resolution through Lok Adalat, will drive the litigants away from the Adalats. Lok Adalats should resist the temptation to play the part of judges and constantly strive to function as conciliators. The endeavor and effort of the Lok Adalat should be to guide and pursue the parties with reference to principles of justice, equity, and fair play, to compromise and settle the dispute by explaining the pros and cons, strengths and weaknesses, advantages and disadvantages of the respective claims. Then, the order of the Lok Adalat, in this case, extended above, shows that it assumed the judicial role that hurt parties ignored the absence of consensus and increased the compensation to an extent to consider just and reasonable. Same to your lordship. Some terms were incorporated which they don't have to consider just and reasonable in the event of default. And increase the compensation to an extent and consider just and reasonable by a legal order which is adjudicatory in nature. It erogated to the extent the appellate power of the High Court and allowed the appeal and directed the respondents the appeal to pay the enhanced compensation of 62,000 in 3 months. The order of the Lok Adalat was not passed by consent of parties or in pursuance of any compromise or settlement between the parties. It is evident from the observation that if the parties object to the proposed order, they remove the High Court within 2 months for disposal of the appeal on merits according to law. Such an order is not an award of this Adalat. being contrary to law and beyond the power and jurisdiction of the government, it is void in the eye of law. Such orders which impose the views of the local adults and the parties, whatever be the good intention behind it, bring a bad name to the local adults and legal services. This is precisely the point I was saying, Mr. Worship. Paragraph 12. It is right that where a law is made by the local adult in terms of a settlement arrangement between the parties, which is duly signed by parties and next to the award of the local adult, it becomes final and binding on the parties to the settlement and becomes executable as if it is a decree of a civil court. No appeal lies against it in any court. If any party wants to challenge such an award based on settlement, it can be done only by filing a petition on Article 26 and Article 27 of the Constitution. That's one very limited grounds. But we know what the settlement is signed by the parties and the order of the local adult does not refer to any settlement, but directs the respondent to either make payment if they breach the order or approach the High Court for disposal of freedom of merits. If it is not agreed, it's not in the law of the local adult. The question of challenging such an order is a petition on the rights, as long as interest in such a situation, the High Court not have heard the case of the on merits. Then paragraph 14. We can use paragraph 17 and 7. But the debate continued in view of the already 11 Act 2002, or by the single judge, quoting that a petition under Article 27 has to be filed to challenge the order of the order. The appellants filed a petition under 27. The said petition was dismissed by another single judge in the north that the order of the order passed on 381 had attained finality and the objection to it were dismissed on 11 May 2002. And a petition under Article 227 was not material to challenge the order of the government. He failed to notice that the order dated 3/2001 was neither a decision nor an attained finality. He also failed to notice that the objection to the order was not rejected by the High Court after consideration in merits. He also noted the fact that the middle judge who decided the appellant's application and directed that the order of the amendment should be challenged by filing a petition on Article 27, read that as it may. Thus, we find that the local adult exercised the power of jurisdiction not vested in it. On the other hand, the High Court twice refused to exercise the jurisdiction vested in it, thereby denying justice and driving the appellants to this court. In this process, a simple appeal by the legal heirs of the deceased for enhancement and compensation could be tossed around and spent for more than 8 years, putting them to avoid the expenses. This is the first one I mentioned. Then the next one is 2012, USC, So we have given a case under the Negotiating Instruments Act. First place before the local adult. So the objection was taken that the local adult doesn't contemplate the handling criminal cases. The question formulated by a High Court in Gauhati case is whether the magistrate can convict the accused position as not the NIA after the award was passed in the law. The only single judge of the 30th section 1 of the Act and the order of the magistrate has concluded as an. And there being good settlement in the local adult, the only magistrate could have proceeded to the judge and delivered the judge. This is precisely the point of it. If there was no settlement, the DRT could have taken it back. But once there was a settlement, the DRT could not have taken it back. For which there is no bar. In the instant case of the budget by both the general action, the awards of the award passed in the government based on the consensus of the right and the party. As for the award, the accused petition have paid recently 3,75,000 to the respondent completed on before 2007. As it is an award paid by the government, it is final and binding on the parties to the criminal division and is contemplated as section 1 of the Act. This is the legal services of the Act. No appeal shall lie to the court against the law. In such circumstances, the petitioners could have filed the execution petition before the appropriate court seeking the award not to be paid with interest and costs. In such circumstances, it is clear that the JMFC became functus official. So once an award has been passed by the magistrate, it becomes functus official to decide the case after the award passed by the local, with the benefit taken on section 138 of the negotiable instrument act. Hence, the interim order passed by the legal section is also not sustainable in the law. However, in here, when the accused petitioner here, after having given consent to the award being passed and also agreed to be the award among the 3,65,000 or before 3,97 in this one, and not complied with the undertaking week before the award, which not be considered. However, the order passed by the JMFC in the section 138 of the NIA has to be said the same. This is the point I'm trying to make in motion. The DRT cannot take back the matter and issue fresh orders. In view of the award passed in the sections 21 I and B, 21(2) of the Legal Services Authority Act, as the judicial magistrate became functus official. And the award is an executive degree in the area of law as per section 21 of the Act. So this was the only course available to the Bank of Baroda election. The DRT had become functus official. After arriving at such conclusion, the single judge made it clear that as per the law of the responding to plaintiff is a deposit file execution petition before the appropriate court to get the award amount of rupees 3 lakhs in fact filing, reimbursed with subsequent interest and costs as well as proceeded in the law. Then 26 here. Paragraph 26.
So your case is that if there is a violation of the order passed by Lok Adalat, then the other party can resort to execution proceedings
Yes, sir.
to recover the amount.
Yes, sir. Not through the process of the DRT anymore. The DRT is now functus official. So the orders passed after 25-23 are wholly without jurisdiction after the passing of the order. And consequently, Your Worship, the order issued by the Additional District Magistrate saying that I will be dispossessed from my property tomorrow is bad in fact. And in this Patna case in auction, which I placed here, in this case, the High Court has said all orders after the issued after the award.
Let us see that.
They begin from the first page.
11, para 11.
That's why I'm giving this copy. No, that copy is. This is from the website.
This is
It's the same that we want.
195.19.0222. Ah,
Very well.
yes.
This is dated, this is the 1986-824. The petitioner is the appellant who is aggrieved by the refusal of the learned single judge to interfere with the proceedings initiated by the bank against the order of the law, done before the DRT, passed under section 1925 of the Recovery of Debt and Bankruptcy Act 1993. The petitioner was also aggrieved with the recovery proceedings initiated against him before the settlement arrived at the local court. This is precisely the same case. The order of the local court is produced as a testament to the petition, and the order of the DRT interfering with the same is produced as an annex B. The learned second judge found that initially a settlement of rupees 7 lakhs was arrived at, and despite the petitioner having not complied with that, DRT had an incident application filed with it, and further that the petition to the petitioner based on petition, which was not permissible. So even the DRT has got no authority to even extend the time allowed in Russia in terms of this. Once an award has been passed. The time granted by the DRT would also become permissible with recovery proceedings already initiated based on the early orders of the DRT, which was passed on the lip checking of complying with the earlier order of the government. The last of such orders can be serious application which granted further time for the petition was pending before the appellate. The certificate of recovery already issued by the DRT was still valid. The order of the law including the petition was clearly at least this interpretation, wherein the banks used the recovery as.
Mr. MT, are you appearing for the other side?
So I'm discussion about that. What's about this? Whatever submission given for alert, only I agree that local alert is exercise is down on the foundation of.
The DRT has now become functus official.
Yeah. Article 39A of the Constitution.
Can you take instructions and come next week? In the meantime, we stay this. We listed for hearing. I think it is only to do with question of law.
Yes, duty. Otherwise, local law.
No, you are appearing for?
I have no instruction from the Bank of Baroda, but responding to
And
yes. Otherwise, local law duty is to settle the claim. And whatever settlement given by the local law, it is equivalent to the order 23 rule 3 CBC. compromised it. I mean, compromised it. That, so it is not I mean, that cannot be again, proof for the kilometer also. The party has to prove for the execution only.
Can we list it for hearing next week?
Because we are selling the same book only.
Because it has to go to the back of the government by this. For 2 weeks.
Heard Mr. H. Learned counsel for the petitioner. And, okay, Mr. H. Jimoni, learned counsel for the petitioner. Mr. Oh, no. By filing the present writ petition, the petitioner has impugned the order dated 28 March 2025, passed by the additional district magistrate, office of the deputy commissioner, Dimapur, Nagaland. Stop. The issue raised in the present petition pertains to the order dated 13/5/2023, passed by the DRT Gauhati, sitting as the Lok Adalat. In the DRT, the order so and so passed by the DRT sitting in a Lok Adalat proceeding. It is submitted by the learned counsel for the petitioner that once the order dated 13/5/2023 has been passed by the Lok Adalat, correct?
Yes, sir.
The DRT Gauhati cannot initiate further proceedings on the subject matter of the order dated 13/5/2023. What was the last line? Excuse me. On the subject matter of the order dated on the subject matter of the order dated 13/5/23, and take further recourse of the proceedings before the office of the deputy commissioner. Yes. Once the order is passed, the DRT cannot take further proceedings and take up the matter before the deputy commissioner, Dimapur.
No, Your Worship, he is just the officer who takes possession. Not the proceeding. before.
And
Limiting agents only.
So the TRT itself cannot issue any further order.
what was that? And take further recourse of the proceedings before the deputy commissioner, Dimapur.
DRT, ma'am. Before
No,
DRT.
and take further recourse means I am referring to the DRT. DRT cannot take further recourse to the proceedings before the deputy commissioner, Dimapur. Because the DRT has become functus official.
No, but in this case, the DRT has resumed the case. Your Worship. That's the point.
Okay, what was that? Okay. Slowly, by the Lok Adalat. On the
That-
subject,
That was.
on the subject matter, stop. On the subject matter, stop. It is accordingly submitted that the DRT Gauhati, after passing the order dated 13/5/2023, has become functus official and has no jurisdiction. To further take up the proceedings. Stop. Issue notice to the respondents, returnable in 2 weeks. 3 weeks, 3 weeks time, returnable in 3 weeks. Returnable after 3 weeks. Mr. Im Tim So, the learned additional AG, appears for the respondent number two and three. Therefore, no formal notice let be issued to the said respondents. Stop. The learned counsel for the petitioner shall take steps for service of, for serving the requisite copies of the writ petition to the learned additional AG. When? In the course of the day. Insofar as the respondent number one is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered postpaid AD within a period of 2 days. 2 days from today. Stop. In the interim, considering the submissions made by the learned counsel for the petitioner and the materials available on record, the order dated. Yes, the order dated 28/3/2025, passed by the additional district magistrate, Dimapur, Office of the Deputy Commissioner, Dimapur, Nagaland, shall remain suspended till the next returnable date. Yes, please.
The certified copy be delivered to me today itself.
Yes. The registry shall take steps for issuing the certified true copy of this order to the learned counsel for the petitioner in the course of the day. Okay. Any more? Oh, I've never afraid of home. Yeah,